Welcome to this explainer. Data privacy used to just be this annoying IT headache, right? But looking at our sources today, it is absolutely clear that it's become a massive top-tier business imperative. So today, we're going to put on our corporate compliance officer hats. We're going to translate the incredibly dense legalese of the General Data Protection Regulation, the infamous GDPR, into a clear, truly actionable roadmap. We're decoding the regulatory text together to uncover the exact structural framework you need to build a literally bulletproof compliance strategy.
Okay, let's dive into this and look right at the bottom line risk of noncompliance: 4%. Under the GDPR, fines can reach up to a staggering 4% of your company's worldwide revenue. I mean, really think about that for a second. For a company with $1 billion in global revenue, you are looking at a maximum fine of $40 million. For some companies out there, that is literally more than their entire annual marketing budget. This completely reframes the GDPR. It's not just some obscure privacy law. It's a top-tier business risk that absolutely demands the immediate attention of top management.
So here is our roadmap for today. We're going to cover 1. The high stakes, 2. Controller versus processor, 3. Consent and rights, 4. The accountability checklist, 5. The DPO, and finally, 6. International transfers.
Let's kick things off with Section 1, the high stakes, financial penalties.
So the GDPR actually breaks fines down into 2 distinct tiers, which reveals exactly where the biggest financial traps lie. The lower-level fines, which by the way are still absolutely massive at up to 2% of global revenue or 10 million euros, those target operational failures. We're talking about things like failing to keep proper records, messing up data protection by design, or forgetting to notify authorities of a data breach. But then look at the higher-level tier, up to 4% or 20 million euros. These are reserved for violating the core spirit of the law. Think infringements on basic processing principles, failing to get proper consent, violating the actual rights of the data subject, or illegally transferring data across borders. Knowing these 2 tiers tells you exactly how to prioritize your risk mitigation efforts.
Moving right along to Section 2, Controller versus Processor. Know your legal role.
And this brilliantly illustrates the binary nature of EU privacy law. You are generally either a controller or a processor. It's that simple. The controller is the entity that determines the why and the how, the actual purposes and the means of processing personal data. Because they call the shots, they carry the primary legal responsibility and, honestly, the heaviest compliance burden. The processor, on the other hand, well, they're the entity doing the actual data processing on behalf of the controller. Their actions are strictly governed by the instructions provided in a contract by the controller. If you're a processor, you have to follow those instructions to the letter, or you're opening yourself up to some massive liability.
Section 3. Consent and rights. Protecting user data.
Now, what's really interesting here is how incredibly detailed the EU definition of consent actually is. You can completely forget about hiding a pre-checked box at the absolute bottom of a 50-page terms of service that literally nobody reads. No way. For consent to be legally valid under the GDPR, it must be freely given, specific to the purpose, highly informed, and it requires an unambiguous affirmative action by the user. And the disclosures, they are extensive. Before a user consents, the data subject must be told exactly who the controller is, exactly why the data is being collected, the specific types of data involved, their absolute right to withdraw consent at any time, and any risks of international transfers. If you miss even one of these elements, boom, the consent is invalid and you're processing data illegally.
Okay, so once you actually have their data, you must respect the 8 foundational rights guaranteed by the GDPR. This includes the right to access, rectification, and the incredibly famous right to be forgotten, or the right to erasure. Individuals also have the right to restrict processing, port their data to another service, object to processing entirely, not be subject to solely automated decision-making, and be thoroughly informed. But here is the absolutely critical operational takeaway for your compliance team. You have a firm, strict requirement to respond to these requests within 1 month. And generally, you can't even charge a fee for doing so. Building the internal plumbing to locate, package, or delete a specific user's data across your entire massive organization within 30 days, well, that's quite a monumental compliance task, to say the least.
Next up, Section 4, the Accountability Checklist, Demonstrating Compliance.
So how do you demonstrate compliance? This is the exact question that keeps compliance officers awake at night, right? It's not enough to just follow the GDPR.
The core principle of accountability mandates that a controller is responsible for and must be able to visually and clearly demonstrate their compliance to regulators.
Let's see how this actually builds into your accountability checklist. Translating the regulation into actionable steps, you basically need to do 3 critical things. Step 1. Maintain incredibly detailed, up-to-date records of all your processing activities. Step 2. Document every single personal data breach. And yes, that means even the ones not requiring notification to the authorities. You still have to internally log the exact nature of the breach and the remedial measures you took. Step 3. Conduct regular data protection impact assessments, or DPIAs. To do this practically, your checklist should include identifying the need for a DPIA, mapping the data flow, assessing privacy risks, and finally, documenting your mitigation measures. This checklist takes privacy from an abstract, high-level theory and turns it into a documented daily business practice.
Section 5. The DPO, Oversight and Governance.
So, not every company needs a data protection officer or DPO, but there are some very specific criteria that trigger a mandatory designation. You need a DPO if you're doing large-scale monitoring of EU data subjects, or if you're engaging in the large-scale processing of sensitive personal data. We're talking things like health data, genetic data, or biometric info. If triggered, your DPO must possess relevant legal expertise in data protection. But listen to this, because this is the absolute golden rule here. Independence. The DPO absolutely must act as an independent contact point. They literally cannot hold conflicting duties. This means the person determining how data is processed cannot also be the exact same person tasked with monitoring that compliance. Makes sense, right?
Now for Section 6, International Transfers, Cross-Border Data Flows.
To really understand data transfers, you have to look at this highly volatile timeline. The core issue here is the intense tension between EU privacy standards and the surveillance practices of foreign nations, particularly the United States. Back in 2015, the European Court of Justice struck down the US-EU Safe Harbor Agreement in a landmark case known as Schrems I. Then, its replacement, the Privacy Shield, was subsequently struck down in 2020 in the Schrems II decision. In both cases, the court cited major concerns regarding U.S. government surveillance programs. Fast forward to July 2023, and the EU-US data privacy framework was finalized, putting in place new safeguards. However, privacy practitioners widely expect this third agreement is also going to face some fierce legal challenges within the EU legal system. The whole landscape is just in a constant state of flux.
So, the crucial point is finding a reliable legal basis for transfer when those macro-level agreements are constantly shifting around. For most businesses, the answer is standard contractual clauses, or SCCs. This is basically an appropriate safeguard where a company makes a legally binding contractual promise to fully comply with EU law and willingly submits to the supervision of an EU data protection authority. In practice, SCCs are by far the most common fundamental legal mechanism used by companies today to authorize those cross-border data flows.
But wait, what if you're a massive global enterprise and you're just trying to share HR or customer data internally between your own branches? Well, that's exactly where binding corporate rules, or BCRs, come in. This is a purely internally focused mechanism that allows multinational companies to transfer data internationally among their own affiliated entities. But don't be fooled, this is not a quick fix. A company's internal practices have to be rigorously assessed and officially certified by a data protection authority before BCRs can even be used.
Now, if an adequacy decision, an SCC, or BCR just isn't available, you are left with derogations, which is basically just fancy EU legal terminology for exceptions. These include obtaining explicit consent for the specific transfer from the data subject, transferring data that's strictly necessary for the performance of a contract, doing it for important reasons of public interest, or for the defense of legal claims. But here's a quick word of warning for all you compliance officers out there. EU regulators have interpreted the scope of these derogations very, very narrowly. They are a fallback. They're meant to be applied only so far as is strictly necessary, absolutely not as a foundation for routine, massive data transfers.
We've covered the staggering financial stakes, the highly complex operational frameworks, and the constantly shifting geopolitical realities of data transfers. So I want to leave you with this final provocative thought. Take a hard look at your own organization right now. As global data flow laws rapidly evolve, is your current compliance posture a reliable shield, or is it a ticking 4% liability? Use the checklists and frameworks we've discussed today to critically evaluate your readiness. Because honestly, in the era of the GDPR, the cost of guessing wrong is simply way too high. Thank you so much for joining me for this explainer, and hey, good luck out there.